This is a press statement by the petitioners in the matter of the petition for the removal of Ms. Charlotte Osei as the chairperson of the Electoral Commission. 1. Ladies and gentlemen of the media, fellow colleagues of the Electoral Commission, fellow Ghanaians, we deem it a great honor to address the nation at this point in our quest to liberate the Electoral Commission of Ghana from the wrong course it took upon the assumption of office of the immediate past chairperson of the Electoral Commission. 2. We have invited you here in our capacity as the petitioners in the just ended proceedings which culminated in the removal from office of Ms. Charlotte Osei as the chairperson of the Electoral Commission. Between the time we presented our petition to the President of the Republic of Ghana, His Excellency Nana Addo Dankwa Akufo-Addo, through to when the Honorable Chief Justice made her prima facie determination, and finally to when His Excellency the President acted upon the recommendations of the committee and removed Ms. Charlotte Osei from office, we have observed with keen interest conversations and discussions in the media on all facets of the issue. We have formed the view that a calculated attempt is being made to distort the facts surrounding the entire matter in a bid to impugn the process that led to the removal of Charlotte Osei from office. In view of the in-camera nature of the proceedings, we were advised not to respond to the issues as they unfolded. However, with the conclusion of the matter, we deem it an opportune time to address those issues which, in our opinion, are deliberate misrepresentations of the facts and, in some instances, outright lies. 3. The first issue we would like to tackle is the issue of the non-existent or otherwise of petitioners in the matter. We remind you of the propaganda which was fed to the Ghanaian populace to the effect that the petition had no petitioners. We state emphatically that the petition was presented by 17 workers of the Electoral Commission. The names and signatures of all petitioners were presented to the President as part of our petition, which also presented same to the Chief Justice to determine whether a prima facie case had been made against Ms. Charlotte Osei. It is unthinkable to suggest that the President of the Republic of Ghana would receive a petition without petitioners and forward same to the Chief Justice, who would proceed to make a prima facie determination without first satisfying themselves of that there were petitioners. 4. In fact, the existence of petitioners in this matter was a matter well within the knowledge of Ms. Charlotte Osei and her lawyers. Under cross-examination of Mr. Forsen Ampofu, our representative and witness at the hearing of the petition, lawyers of Ms. Charlotte Osei mentioned at least three names of petitioners. For instance, they asked Mr. Forsen whether or not Bernice Asante, one of the petitioners, was present at a particular meeting of the petitioners. They also acknowledged Mr. Goswin Dojo, who was present with Mr. Forsen at every sitting of the committee. In addition, they asked questions about Mr. George Ajavukawe. They asked questions about when Mr. George Ajavukawe died. The question is, if the respondent was not made aware of the petitioners, how did they know that there were at least 3 persons, apart from Mr. Forsen, who were part of the petitioners? 5. We are also aware that it has been put in the public domain that the petition was filed on our behalf, on behalf of a deceased person, Mr. George Ajavukawe, and so same is fraudulent. With all due respect, this is a complete lie, manufactured to court public sympathy, which is non-existent. The ridiculous nature of this claim is exposed by the record of proceedings. In the record, lawyers of Ms. Charlotte Osei asked Mr. Forsen Ampofu if he was aware Mr. Ajavukawe had died in November 2017, to which Mr. Forsen Ampofu answered he was unsure of the date. Now, it is public knowledge that we presented our petition in July 2017. Therefore, if Ms. Charlotte Osei's own admission, the gentleman died in November 2017, wherein lies the fraud. We do not intend to waste time on this matter, as the lie is obvious to everyone, except those who fabricated it. We wish to state that, even though there were 17 petitioners, in proceedings of this nature, all one needs is just one petitioner, and therefore the reliance and peddling of such a falsehood with the intent to impugn the process looks very bad and akin to a drowning man clinging to straws. 6. At this point, we deem it necessary to give a brief background of the grounds upon which we sought the removal of Ms. Charlotte Osei as chairperson of the Electoral Commission. In Charlotte Osei, we had a chairperson who ran the commission as if it was her own personal property. She acted unilaterally in many instances without the knowledge of her fellow commissioners. She gave out contracts without recourse to the law and procedures made to regulate her conduct in that regard. She ordered payment of monies to institutions that had no contract with the Electoral Commission. The evidence presented at the hearing of the matter were overwhelming and only led to the conclusion that she was incompetent to hold that position. The evidence also clearly showed a pattern of reckless and unimaginable behavior on her part, for which her removal was justified, no matter how one looks at the matter. It was therefore no surprise to us that the committee found her liable on all 6 grounds for her removal. 7. It is strange that some persons would condemn the removal of Ms. Charlotte Osei and yet extol the removal of Ms. Loretta Lamte, former Commissioner of Shraj, when, as it were, they were both guilty of spending without requisite approvals. We see that the case of Ms. Charlotte Osei was worse compared to Ms. Loretta Lamte. As workers of the EC, if we had the chance to tolerate the infractions of these 2 public officers, we have no doubt that we would prefer one over the other, and the choice is obvious. Whereas Ms. Loretta Lamte was sacked for spending about $200,000 without due process, Ms. Charlotte Osei in some instances gave contracts over $7 million above her approval limits. If this is not misbehavior and incompetence, then we don't know what else can be. 8. Ladies and gentlemen, the fight for probity and accountability in the activities of Ms. Charlotte Osei at the Electoral Commission is by no means over. First of all the grounds for which she has been found to be liable are also grounds for which she can be prosecuted. The Public Procurement Act 2003, Act 663, is very clear on this. In this regard, we are making preparations to submit these complaints to the Office of the Special Prosecutor for investigations and possible prosecution of Ms. Charlotte Osei. We shall leave no stone unturned in our quest to ensure that she faces the full effects of the law, for which she gleefully breached with wanton recklessness. 9. In addition to submitting the grounds on which form the basis of her dismissal, we are also prepared to submit to the Special Prosecutor complaint and evidence of her dealings with other companies and individuals which we deem to amount to abuse of office, breach of trust, and conflict of interest. We speak of her dealings in the Aerovote contract. We have evidence to the effect that even before the tender into the contract was opened, Ms. Charlotte Osei patently ignored the conflict of interest situation when she recommended, supervised, approved, and awarded a contract of 7,235,008 Ghana cedis to Aerovote Security Printing Ghana Limited, whose director used to be a client of Prime Attorneys, a law firm owned by Ms. Charlotte Osei. Even before the procurement process began, there was email correspondence between Ms. Charlotte Osei's lawyers, Prime Attorneys, and a representative of Aerovote Security Printing Ghana Limited about the procurement process that was yet to begin. Aerovote Ghana Limited was not included in the initial shortlisted companies by the Public Procurement Authority to print the carbonized papers, also known as pink sheets. Following Ms. Osei's correspondence with the representative of Aerovote, she applied to the PPA to alter the initial approved list to include Aerovote. She, in the process, excluded Messrs. Backpress Limited, a registered commission supplier, whose tender was the most price competitive. Messrs. Backpress, upon realizing that it had been unfairly treated, petitioned the Public Procurement Authority. 10. There are many contracts which she awarded without recourse to process of law, and we are willing to cooperate with the Office of the Special Prosecutor to investigate each and every contract to bring her to book in instances where she is found culpable. 11. Ladies and gentlemen, we at the Electoral Commission would like to say that we have seen the removal of office of Ms. Charlotte Osei. We like her removal and it makes us happy. We are sure these words are very familiar to her and fellow Ghanaians. In line with this, we wish to state that we shall use all legal means available to us to ensure that her removal is permanent and cast in stone. We welcome persons who in the exercise of their constitutional rights are seeking to impugn the process. We shall also do all we can to uphold her removal. We shall conclude by thanking all Ghanaians who have followed this process with keen interest. We believe it should serve as a source of inspiration to many others to advance the cause of our nation by bringing public office holders to book when they act against the laws of our land. No one is above the law, and Ms. Charlotte Osei is no exception. We also would like to thank our legal team, Mr. Kwame Boateng, Mr. Maxwell Opoku-Agyemang, Mr. Eric Otredakon, Mr. Julius Opoku-Agyei, Mr. Raphael Kweku Owusu-Agyemang for their dedication to our cause. Finally, we would also like to thank the President of the land, His Excellency Nana Addo Dankwa Akufo-Addo, for executing the recommendations of the committee. Thank you.